Well, I'm Debbie Nieman. I'm with Hope Trust. My background, like they said, I was with Northwestern Mutual doing special needs planning. But one of the questions that I continue to get that I didn't have a good solution for was, okay, we've got the legal piece taken care of, we've got the money piece taken care of, but how does this translate into the day-to-day support that I'm providing for my child or my loved one? Who's going to do what I'm doing? And I didn't have a good answer for that. We now have that. And so that's why I switch gears a little bit, because my role at Hope Trust, not only am I training other financial advisors to do or be aware and educated in the special needs planning space, because it's kind of it's not just a specialty, it's a subspecialty, but also helping families answer that question. So there's the three main questions, and we'll go over that in this presentation, that I hear the most is, how much is it going to cost? Do I have enough? And then how is somebody going to step into my shoes or my role and help and make sure my loved one's taken care of in a good way? So we're going to talk about this. Your heads will probably spin a little bit as we go through this, and by the end, your eyes might be a little bit crossed. That's normal. So I'm just preparing you for that. But I try to talk about it in a simple form as possible. And this is something that's very complex. It's also something very important. So I'll give you some tips along the way, whether it's tools, what to bite off first, how to prioritize, and all that. Now, some of you may have done some of this. Some of you may have done all of it. Some of you may have never heard any of it. And that's okay. I see that all the time. So there's no question off the table. Please feel free to ask. If it's too terribly specific, I'll tell you that, and that'll be off, something that maybe an email can be sent to me or something, but I'm going to try and speak to the majority and kind of to the general. So it takes a village. We know that when we're raising children, regardless of disability, it takes a village. It takes an even bigger village when we're raising somebody or supporting somebody with disabilities. So when we think about, what keeps us up at night, especially those of us that are parents, it's what if something happens to me? And we think even more when we think about our kids that have special needs or disabilities, whether they're adult or children or minors. It's something we think about. Usually the first thing we think of it when we get up in the morning, and the last thing we think of when we go to bed at night. It's not something that's going to get resolved, though, by just thinking about it. We have to do something. Ideally, we started this planning when our child got a diagnosis. Now, I will admit, when my child got her diagnosis, that was not what came to my mind. And there's a whole emotional process and all the other things you have to know. So I understand that. But today's the day to start that planning. And so we can break it down into manageable chunks and we can prioritize, but we have to do something. Doing nothing, I can guarantee you, will not give you the outcome you want. So keep in mind, right now is the time to start planning. It's a complex process. You don't have to do it all at once. You're going to manage it. We can break it down into small punts. And then it's not a one and done experience. It's not like you get through this whole thing and you're done. It needs to be reviewed, just as the individual is going to evolve and change, and things are going to come up, and life situations change, and people change, and all kinds of things. This process has to be, or this planning has to be reviewed at least on an annual basis. And anytime anything major changes in relationships, life, whatever comes up, but we are constantly reviewing this. This is not something you put on in a binder, on a bookshelf, and blow off the dust every 10 or 15 years when you think, oh, maybe it's a good time to look at it. For it to be effective and do what you want, it needs to be reviewed regularly. So today we're going to cover the four main areas that make up comprehensive special needs planning. I'm going to talk about some tools. We're going to talk about how to go about building the village and who needs to be part of that village of support, and also some other important planning considerations that, through my experience of talking to other families, that I see are often either sore spots or areas that are often overlooked. So let's get started. So as you heard everyone mention, I have a daughter with special needs. My daughter does not have FOP, but she has cerebral palsy and really complex medical issues. She's actually in the hospital right now. So our hospital is our second home for her. And so that's just what she does. But I'm very familiar with life in a wheelchair and how things are not very wheelchair accessible for a lot of the world. But I got into this because of her, because I wanted to do her planning, and I realized it was so siloed off. And I felt like, okay, I went to the estate planning attorney, but he couldn't answer these other questions, and I didn't know who to go to figure out the financial piece of it. And then I couldn't find out all the other pieces. So what do we do as parents? When there's not a solution, we create it. And so that's how I got into this. So let's talk about the 4 pillars of comprehensive planning. One of the things that we need to talk about is the money. That's the financial piece. The other piece is government benefits. Now, I've had families who say, I don't even want to mess with that. Well, that's great if you don't want to mess with it now, but you can't say forever. We don't know what to expect down the road. We don't know when you're no longer here. So protecting those government benefit eligibility is going to be key. And that's what has a lot to do with this planning. Legal perspective, making sure your wishes are documented and your loved one with disabilities, as well as protecting, again, that government benefit eligibility. There are legal things we have to do. So there's a legal component so that if you leave inheritance, that you are not harming that individual, you are helping them. And then finally, the life care plan. That's going to be aggregating and organizing all the information, the nuances, the tricks, the details. I mean, if we step back and just look at the medical stuff for your loved one with disabilities, it's a lot to keep track of between DME, DMS, all the providers, all the medications, all the different pharmacies, case managers if they're involved. And that's before we get into who the person is and all the different things there. So, when I ask families, where do you keep all that information? I mean, show of hands, how many of you have it in one organized place that can be found if you got hit by a bus tomorrow and nobody, and you weren't here? That very few people can say, yeah, I got that down. Most people are like, oh, well, I've got a paper file on my desk in the second drawer. I've got some in my head. I've got a list over here. I have some stored on a computer. We've got to come up with a better backup plan. So my kind of mantra is always, we're going to plan for the worst and hope for the best. We're going to make it though, so that continuity of care and that individual, their needs are going to be met, even if somebody has to step into your shoes tomorrow. So the first step when we're looking at the financial piece is, how much is it going to cost? And many families are like, I don't know. I know what it costs now, but I'm providing half the support. And, we don't know how much Johnny's disease is going to progress. He may be in this scenario in 10 years from now, or he may be where he's at right now. How do we plan for that? And again, then we're going to take a step back and look at averages. We know what we know and we know what we don't know. So we're going to try and look at averages. There's people that have been down this road before us. Now, I understand there's been major pharmaceutical advancements and medical advancements for FOP, which is wonderful. But we also know that comes with a price tag. So we do need to step back and look at those things. What is that going to cost? Is insurance going to be covering that out-of-pocket expense? What are other things? If your child was to have a major FOP flare and then end up becoming dependent on a wheelchair, that's a lifestyle change. That means modifications to vehicles. That means modifications to cars. You might want to run a couple different scenarios of, okay, let's say that Johnny's fine now, but maybe at 25 or 30, we think they may end up needing a wheelchair or something. Let's budget that in. Let's run a scenario looking at that. And we can do that. We have a tool at a Hope Trust that can help you do that. Some other things you need to think about, and this is the piece that I find families really forget about, is how much usually it's mom or dad is doing for free. If you are no longer here tomorrow, who's picking that up? And if you have had to quit a job in order to support your loved one, and the guardians are let's say your brother or sister, and they already have a family and careers, then what kind of financial toll is that going to take on that family and time? Because everybody only has 24 hours in a day. So if that's the case, we need to account for that financially as well. Or if it's your other adult siblings, or other adult children taking care of a sibling and stepping in, how much needs to be hired? Not maybe all of it, but maybe some of what you do may need to be hired. You need to incorporate that into the budget. And then just making sure you're thinking about some of those things as with disease progression and the aging process that could come into play to make sure that we have that there. Once you've completed that, then the next question is, well, do I have enough? And how do I figure that out? We have a tool called, we call it MITO, Meet Your Trust Objective, but basically it runs a Monte Carlo. For those of you that have no idea what I'm talking about, in the financial advising world, that's what they use on the backside based on historical last 30, 40 years of what's happened in the economy to project how likely what you have is going to last. Whether it, and it takes all the history. So worst case scenario, best case scenario, everything in between, but it's all based on history. And it's like 1,000 different scenarios that are ran through the numbers. So it looks at how much is needed, which is what we just determined on the previous slide with the budget, and then applying the assets that are going to be utilized based on asset class and everything else in historical, and running them through a bunch of scenarios and identifying, okay, is there enough for all of these scenarios? If there's not, then what's the gap? Because I need a quantified number to figure out how we're going to address that gap. And then you can work with your financial advisor to figure out what's the best way, whether it's life insurance, whether it's, looking at, okay, maybe we're not doing a 50-50 split between my two kids, we're reallocating, whatever that may be. But that's where your financial advisor is going to help you with that. On the note of a financial advisor, you need to work with a specialist. I mentioned that, when you guys found out your children had FOP, or when you yourself found it out, you don't go to a general practitioner. You don't even go to a specialist. You go to a subspecialist who really knows FOP. This is the same thing. You need to go to a financial advisor who specifically does special needs planning. They may not do entirely special needs planning for their practice, but they do a good chunk of it. A good way to check on that, and not all the time, but generally speaking, there is a special designation for special needs planning called the Chartered Special Needs Consultant, CHSNC. A lot of times you see financial advisors and they have like 26 letters after their name. It's the different designations they have. It's extra training that they did through the American College of Finance, CHSNC. There's only about 300 of us nationwide. I highly recommend using somebody there. They've done specialized training for this. They understand and appreciate a lot of the different nuances and things that need to be considered that many financial advisors simply, they don't know what they don't know. So make sure you're working with somebody and they can help you best address those needs. So one of the tools when we're talking about trying to save, okay, so I haven't gotten to the government benefits piece, so I kind of have to go around because I wanted to be somewhat organized. But generally speaking, with government benefits that are asset-based, that limit of assets the individual can have is $2,000 in total. Now, if I get taken out by a bus tomorrow and I leave nothing but $2,000 to my daughter, that is not the lifestyle she is used to, and that's not going to go long. We all know that. That $2,000 is not very much. But how do we go about having them save money or being able to put money away without it jeopardizing those government benefits? ABLE accounts is one way. It is not the only way, and it's also not the perfect conduit. It's one of many tools. So I just want to make very clear that if you ask me, is it one or the other, or what's the best thing? The answer is it depends. You may need multiple tools. So ABLE accounts came about relatively recently. You have to have had disability onset prior to the age of 26. Anybody with FOP is born with it, so that individual automatically qualifies. They can only have one ABLE account. Anything saved inside of an ABLE account does not count against them as a resource for Medicaid eligibility, so you can save up in there. The first 100,000 in account is not looked at as a resource by Social Security when we're looking at SSI determination, not SSDI, SSI. So they can save up to 100,000 and not have it impact their SSI. Contributions by friends and family are not deemed as income if that person is dependent on SSI. That's a big one. If you were to get gifts of money and put it in a checking account of an individual dependent on SSI, Social Security says, oh, that month you made too much money. Sorry, no SSI this month. But if you put in the ABLE, you don't have that problem. Contributions are federally post-tax dollars, so they're not tax deductible. But many states programs, contributions to them in part or in total, are state income tax deductible. So if you're looking for a tax deduction too as a contributor, you may be able to get a state tax deduction. The monies inside of an ABLE account grow tax-free and come out tax-free as long as they're considered a disability-related expense. Now, but let me explain what the definition of a disability-related expense is, and I'm going to read this to you because it's pretty broad. Those are anything that can pay for basic needs, utilities, housing, transportation, education, medical needs, technology, training, caregivers, and anything that improves, and this is key, health, independence, or quality of life. Guys, basically that captures everything. You can take a vacation and use your ABLE account to pay for it. So don't be fearful like, oh my gosh, you know, is it only for a disability related expense? No, if you want to go get if the individual whose account it is wants to go get a mani-pedi and take a vacation, they can pay for it through their ABLE account. So it can be used for pretty much anything. The law was written that way on purpose because they found that individuals with disabilities were having to spend down to stay below that $2,000 and weren't able to save up for, let's say, a modified vehicle or a vacation or that piece of technology that they wanted because it was beyond that $2,000 threshold.
Can I ask a quick question? Where do the ABLE funds go for an estate? So if the person who has the ABLE account passes away.
Yep, that was on my next thing I was going to get to. And that's what my last bullet is about. So it depends on the state where the Medicaid services were provided. If somebody's dependent on Medicaid and they have an ABLE account, from when they open that ABLE account and where those Medicaid services were provided, there's potentially a Medicaid payback on that. So when the individual passes away after funeral and final expenses are paid, if that Medicaid was provided in a state that has a Medicaid payback, those funds can go to reimburse Medicaid for the supports and services they provided. But it depends on the state. Each state is different. There's about, I want to say there's about 15 states that don't have that Medicaid payback. It's not where you have the ABLE account, it's where the Medicaid services were provided. So for those that are concerned about that, I would suggest then keeping the balance in the ABLE account lower, maybe below 100,000. Usually if you keep it around between 50 and 70,000, if somebody were to pass away, funerals and final expenses, you may have a more elaborate final funeral or whatever celebration, maybe a destination one where a beach is involved or something. But you should be able to spend most of that and not just be throwing it back to Medicaid. They don't go beyond that though. So it's just whatever is left there. What was I going to say? There was another thing. It'll hit me later, but
one other quick, the 100,000 is based on contribution or account balance. So
account balance. So if you put it in and you invest, when you choose an ABLE program, there are investment options already predetermined and you choose which of those options you want. And each state does it a little bit differently. Like my resident state is Kansas. You don't even see what you're investing. You don't see the mutual funds. You do it by risk tolerance. Other states, you actually get to see the different mutual funds you're choosing and you can pick and choose what you want to invest in. So it just kind of depends on where you're at. Now, if you, hold on. Sorry. Are there any other questions on that 100,000 or anything? Did I answer your question, Gary?
I just have a quick question. Yeah, is for the Medicaid payback, is there a cap on the payback you have to pay back, or is it an individually based how much they use out of Medicaid?
It'll be individually based. So if somebody hardly used any Medicaid or didn't use Medicaid, it would not go back. So the answer to the question that was 2 questions before, I think you had asked what happens to the monies. If somebody hasn't used Medicaid or there's more in the account than what Medicaid pays back, it goes to the estate through probate or through their will of that individual. And then we'll go on to that. Now in my state, like if for Medicaid services, the payback was removed because they were finding families were not opening an ABLE account here for that. So the Medicaid payback was removed for ABLE accounts in the state of Kansas. So you can name a beneficiary directly for those, in which case then it goes through probate or the will. and then on to who the successor beneficiary is named. Each state is different though. And more states I'm finding is starting to bring that back because they're realizing Medicaid's not going to make that much money from these accounts because most of these accounts are capped. So you can, even if you don't need to stay below the 100,000, I think the highest state is California's, the max that you can have in there, and it's just over $500,000. And while that may be a lot for our family member or whatever to the Medicaid program, by the time it's just probably not going to be worth it. And so I think the trend is going to be more towards, well, I guess I would say that at least a year ago. I don't know now. This year finances are a little bit different when it comes to government programs. So Medicaid's kind of a mess, more so than normal. So that might be different. But as of right now, you know, it depends on where you're getting those Medicaid services and how much were used. Okay.
And just another benefit, at least in New York, I'm able to roll over from my 529 college savings into the ABLE account, which is a big plus, you know, where anything's not used for college. So.
Yeah, thank you for bringing that up. So that's another thing, because ABLE accounts are 529A accounts, it falls under the same part of the tax code as 529 college savings plan. So you can roll a 529 college savings plan if that person doesn't go to college, or if there's monies left over, you can roll that into an ABLE account. ABLE accounts can be used for education, but they can also be used for other things. So the only caveat to the rollover is that you can only roll over $15,000 per year. It's whatever that annual contribution amount is, but you can still do that instead of having to be like, okay, do I put a different beneficiary or do I cash out and take the huge penalty and taxes on it? So this way you can get around that and they can still utilize it.
Debbie, can I ask one other quick thing just to make sure I'm summarizing it properly? Is the only benefit is the tax-free growth and perhaps state income tax, because it's not taxable on the way in.
And it's not tax, you're putting post-tax dollars in and it's not taxable on the way out. The other, and I haven't gotten to this point because I haven't gotten to special needs trusts, but ABLE accounts can pay for things that a special needs trust can't. And an ABLE account, the individual, if they are competent and able to manage so they don't have a conservator or guardian, they have full access to this account and don't have to go through somebody. A special needs trust, which I get into in a couple slides, requires the beneficiary cannot be their own trustee, which means they have to ask for request distributions for every single thing. ABLE account can be used for more things than a special needs trust can, and they can just access it themselves. Obviously, a minor child would not, but somebody who's an adult. And then when we're dealing with FOP, unlike somebody who has a developmental disability and cognitive disability, where we wouldn't necessarily always give them access to their own funds, FOP is not something in that range. So having to go through a special needs trust to access your own assets and inheritance is it stinks. Who is an adult wants somebody controlling their, so that's how we utilize. So I'll get more in depth in how we utilize the two together, but an ABLE account allows a lot more freedom and independence.
Right, but financially, if you're just thinking about the dollars and cents, it's just that it grows tax-free and that growth is not taxable when you pull it out.
Correct. As long as it's used for the beneficiary, the individual. So like if they were to use it for, I don't know, to take the whole family on vacation, the other family members cannot have their part of that vacation paid out of that ABLE account, because then it would be taxed and penalized, only the individual. So
I'm just thinking about a lot of people, they'll open the account, they'll put the money in, it'll be in a money market fund earning 0.2%, and they really haven't achieved anything. If you choose that, if you choose the low risk.
It earns a lot more than that. I mean, you can, so on ABLE accounts, another piece to this is that they are pretty conservative. When you choose, I also want to say, so in the financial advising world, we talk about like cash and then conservative and then aggressive and very aggressive. If you were to look at returns over state ABLE accounts for those definitions, they do not compare to what a typical definition would be for financial, what a normal financial advisor would say those are. So what I found was like the aggressive and very aggressive when the market was hot back in January, a year ago, January, where most things were getting 20% or higher returns. Most of the ABLE accounts that were invested that way were getting somewhere between 9 and 14%. So they are getting a good return, more than just sitting in cash, you know, getting a 0.01 return rate. But they're definitely more conservative, for the reason of that these states realize that for many people with disabilities, this is their only place they are saving money. So they didn't want them to lose the entire bank, because oftentimes that's going to be their only place that they have resources saved. So they do have relatively decent, but it's just a lot more conservative.
And Debbie, with regard to the FAFSA, when you know planning for college and stuff, I don't think you have to report that as an asset of the individual, correct? From the FAFSA?
On the FAFSA side of it, I'm not 100%. I would have to check on that. I'm not 100%. It would be similar to if you have to report it as a 529 college savings plan. So, and I'm drawing up like
the 529 is an asset of the
that's right. That's a little bit different. This really is the individual, not the person who opened the account. So it's a little bit different. I would need to go back and check on that. I apologize. I don't know the answer to that off the top of my head.
Sorry, Debbie, my headset died right when you were answering. So carry on. Don't worry about it. I just don't want to think I was being rude. It just died when you're about to answer.
No, you're fine. If I didn't get your question answered, just ask it again. I don't know when it died. So.
Yeah, no, go ahead.
Yep. And if I seem a little jumpy, I prefer that you guys are interactive and asking questions. So I'll just continue to go back and glance at my notes and just make sure I touch on anything. But if you think of anything, just interrupt. I prefer it that way than me just talking at you, because I think you'll get more out of it. So all the states here in green have ABLE programs. And if you happen to be in a state that's gray, you can open an ABLE account in someone else's in another state. If you don't like your own state's program, generally speaking, you can open another state's program. There's probably a handful of states that don't allow residents that don't allow non-residents to participate. So most states don't care if you live there or not. Just something I want to make sure you're aware of is, generally speaking, and not always, there may be a higher fees associated if you're a non-resident. Now, I had clients who their resident fees of their own state's ABLE program was higher than the non-resident higher out-of-state fees. So again, just be aware when you're looking at that. ABLE NRC, the National Resource Center, ablenrc.org, is a great resource. They have where you can pull up different states' programs and literally compare the differences between them and what the different features are. I love the tool that they have, and it's a great resource to learn more about ABLE programs. They're also pretty responsive. So if you actually put a message in through their online questions and stuff, they usually get back to you within usually a week or two, which for a national setting is pretty good. So otherwise, just work with a financial advisor who can advise you, that knows this stuff, and they can help you with that.
Debbie, I have a quick question.
Yep.
So if it's a minor, you open it in the minor's name, and then you can take money in and out through that minor's name?
The minor cannot, just like a minor does not have legal control of any of their assets until they are 18. Right. Once that individual turns 18, however, that is theirs. So, you know, just like an 18-year-old can open a credit card and max it out too. So it's definitely talking to your child, making sure they understand their responsibility, or maybe, you know, we as parents have a lot of control over our children, even though legally our kids can do anything they want at 18. But we send our kids off to college all the time at 18, and magically they figure things out too. So there is some that, but if you have, obviously your child is a minor, you have control over that account. Oh, another thing, that was what I was thinking of before. Only one ABLE account per individual. So it's not like you can set one up as a parent and then grandma and grandpa set one up and then, you know, whatever. There's one per social security number. So it's just one ABLE account. Okay. Government benefits. So my experience is that most families are not tapping into this or not maximizing. They're leaving money on the table. Now, I will say that sometimes, again, I said this earlier, a lot of families are like, I just don't want to deal with it. But most of the time, families said to me, we don't qualify for anything. And in part, that might be true. The family doesn't qualify, but the individual with disabilities may qualify. And I can see why families get confused, because I was confused for a long time with my own daughter. So first of all, part of it is all the alphabet soup that goes into this. And then some stuff is federal and some stuff is federal funded, but state run. It gets very confusing and all the names sound very similar. So I can see how families get this messed up. It took me a couple of years to get it all straight myself. So I'm going to give you a little bit of a high kind of overview of each of these things. And then we're going to do a couple examples, because I want to make sure that families are stepping back and let's tap into those resources if possible, because we're spending a lot of out of pocket. I know for my daughter, there was a year we were paying $30,000 to $50,000 out of pocket just on like medical stuff. And that over time really adds up. That's a lot of money. So SSI, Supplemental Security Income. To qualify for this, it's for people that have limited assets and limited income, period. I'll give you some scenarios when we get on the next slides, but SSI is totally about what you have and what you're making. SSDI is Social Security Disability Insurance. This is based on whether you qualify, the individual qualifies and meets the definition of disability under Social Security Administration. And then if they're over 18, if they're able to hold gainful employment, and I'll explain more of what that means. Medicaid is insurance for people that have limited assets and income, period. Medicaid waivers is getting access to Medicaid, and they waive some of the normal requirements to be eligible. So for example, and it varies, let me go back. On Medicaid waivers, it varies by state what they waive on their waivers, and it varies by what they provide as well. Each different waiver within a state may have different things waived. So that's why so many people get confused. In my state, my daughter is on a Medicaid waiver. She would never qualify for a traditional Medicaid because her father's a surgeon and I'm a financial advisor. So there's no way she'd meet the criteria because she's still a minor. But they waive that in our state for kids that have her level of medical complexity. So she automatically qualifies, and that becomes her secondary insurance because she's still on our primary. But then it covers things like co-pays, deductibles, co-insurance, and a whole bunch of stuff that our awesome private insurance doesn't cover. So my daughter, for example, uses catheters. Those are not covered by our primary insurance. They're $7 a piece. And you go to the bathroom several times a day. So you can quickly see how quickly that adds up. Some of the modifications to our home paid for, those kinds of things. So DME, DMS, co-pays, co-insurance, and deductibles, all covered by her Medicaid waiver. And then it also does helps with some things like nursing, in-home nursing, and that kind of stuff. It covers those things. So our out of pocket literally in 1 year from when she wasn't on it to when we went from paying $30,000 out of pocket to $1,500 the next year. That's huge. That's huge for us, for retirement, for savings, and also for making sure we have a great funding plan for her if something were to happen to us. So
how do you figure out what your state, Debbie, what your state does? Because you said that's for your state. Yeah,
so each state is different. So one, talking to a social worker, usually at a medical facility, can be helpful. Also, there are government benefit specialists throughout the country. I would start and look and see if your state has somebody, but I've found that the ones through the state sometimes are okay, and sometimes will be like, well, they only tell you about some of the waivers because those are the only ones that are managed at the state level. But if they're managed at the county level, they never mention like, hey, you should talk to the CDDO of the county you're in. That's what happened for my daughters. We got put on a waiver wait list for the state, or excuse me, at the county level that had a 9-year wait list. And they never said, hey, by the way, there's this other waiver, but it's managed at the state level. You should look into it. There was no wait list for it. So if you Google like your state and waivers, and it falls under what's usually it's the HCBS. It stands for Home and Community-Based Services. So HCBS waiver. That should pull up all of them, and you can read through what's the criteria for eligibility, who qualifies for this. A lot of times there's one specific for maybe physical disabilities, for medical complexities, for, you know, you'll see one for usually autism, you'll see that, but I would, in some states, it's just one big one. They're wonderful, but I will tell you that there is a lot, most states have wait lists for them, and we're talking 2 years to 10 years on them. If you get one though, and again, I tell all families, get on the wait list, get on the wait list, get on the wait list. I know it may be a long time, but you will want and need those services at some point, and they can be really helpful. And then finally, Medicare. People get Medicaid and Medicare mixed up. Medicare is generally for people 65 and older, but it's also for people with disabilities. And I'll explain in a couple slides how your child who is not 65 years old yet may qualify for Medicare. Public school services, for those of us that's got kiddos age 3 to 21, I definitely make sure you understand how IDEA works so that you can get as much therapy that this public school pays for instead of yourself. Then VOC services, I don't think most people, usually that's more for people with developmental disabilities or cognitive disabilities, and we don't have that problem with FOP, but potentially VOC could be helpful if we're looking at adaptive equipment, adaptive communication styles, accommodations because of a wheelchair or anything like that. And then if anybody's military, veterans, either active duty or veteran, your loved one with FOP, if they are a child, they oftentimes can have some lifetime benefits through the military, through the VA. That would be very helpful, including like TRICARE for life, or I don't know what they call it. I don't think it's called TRICARE anymore, but it's some kind of health insurance for life. And being able to have stacked difference, so having TRICARE and Medicaid, and potentially later on Medicare as well, the more coverage layers you have, the broader the coverage and less that you're paying out of pocket. So again, just being aware that those resources are out there. So let's talk about
Debbie, one quick question for you. So the income stuff is based on the parents, right? The combined income of the parents.
Let me go to my next slide, because I'm going to explain exactly what you're talking about, because the answer is it depends on the age of the child.
Okay.
So and it also depends on what government benefit we're talking about. So so I'm going to explain that on the next slide. You beat me to the punch. So let's talk about this. Again, many families are leaving money on the table. So let's talk about what are some scenarios. When we are talking about SSI, and if everybody can mute, because I keep hearing in the background, that'll be helpful. Unmute if you need to ask a question though. But for SSI, supplemental security income, this is 100% based on assets and income. If that child is a minor, it looks at everybody, the household income, the household assets of everybody in that house, and the number of people living in that home. That is what determines if that child has SSI. Generally speaking, somebody's got to be living pretty close to the federal poverty level in order for their child to qualify for SSI as a minor. Once that child turns 18, however, mom and dad's assets and income are no longer considered. Just the individual with disabilities, even if they're still living at home. The kicker is, if you, mom and dad, have child living at home and they're 18 or older and you are not charging them, even if it's on paper, room and board or rent, Social Security says, guess what? That's a resource, even if you're not writing your child a check. So we're going to dock their SSI payment by 1/3. So I suggest to my families that once your child starts applying for Social Security, it's time, if they're going to apply for SSI, you need to have some kind of rental agreement. And you can say on an IOU basis, we know you can't pay for this now, so we're not going to charge you interest for back. Well, right now we're in a moratorium still, so you're okay. But anyway, that way Social Security will say you're not gifting it to them. That will maximize that payment for them. And the maximum for 2021 per month is $794 per month. It's not anything tremendous, but that's better than zero, and that can be utilized for something. So then mom and dad charge the child rent and take that payment after it's paid. And mom and dad, as landlords, can do whatever the heck they want with that payment, whether it's utilizing it to support their child, or what often happens is mom and dad then use that and gift it into the ABLE account. And it ends up in for the child to use how they want or to save. So that's one thing. Going back also, Medicaid waiver. Depends on the state, but in my state, the Medicaid waiver for a minor child doesn't look at mom and dad's assets and income. It waives that. It only looks at the child as if they were 18 years old. So the question I think Carrie had asked is whose money's being looked at? Now I will tell you this, a lot of families say forget SSI because you have to keep track of everything each month, income and expenses, and there's a lot of documenting that goes into it, and they have their nose in all your business. So I have a lot of families who end up not doing SSI. But the reason that age 18, you hear a lot of parents like, oh my gosh, or you hear professionals, you need to make sure you're ready. Look and make sure that your child's assets in their name are not, if they're going to apply for SSI or Medicaid, that everything that they potentially have their name associated with a social security number is fair game. So where I've seen families mess up is life insurance policies that flip, kiddie policies that flip the owner to the child at 18. And if that's a permanent policy that has cash value in it, that cash value is an asset, not the death benefit, but the cash value.
Is there a look back, Debbie? Let's say they have assets and you clean them up or spend them on different things.
Yes, Medicaid has a 5-year look back. Medicaid has a 5-year look back. So you do have to be careful in how you're doing things. You can retitle to, if it's in the child's name, if the asset's in a child's name, what you could do is a first party special needs trust, but there still is a look back.
But if your child, for example, has a Roth of their own and there's more than $2,000 in it, then they're screwed.
You're going to have an issue with that. That one you're going to have an issue with. I can tell you that 100%. The areas that I've seen, at least for young children turning to 18, like I said, was the cash value inside of a life insurance policy. And then the other thing I've seen is UGMAs and UTMAs, that well-intentioned grandma and grandpa set up an UGMA or an UTMA or bonds for junior. And then they turn 18 and everybody's forgotten about it until Social Security gets into their business and is like, where's this? What is this?
But is the amount you're leaving on the table is this potential $770 a month,
right? And so for the headache of
the number you got it
right, SSI is probably not the bigger issue here. Medicaid would be. You probably, especially anybody who's FOP, I would think would want to qualify for Medicaid because it becomes their secondary insurance. And regardless, most of our kids will age off of our health insurance at age 26. If they don't work and have those group benefits through work, even if they do, having Medicaid as secondary would be really helpful because I know for a fact, if you have a lot of medical complexities, even with great health insurance, you've got deductibles, co-insurance, co-pays, all that. Medicaid would pick that up. So it's the Medicaid piece of that $2,000 of assets that's really important. The SSI may not be worth it. Like for my daughter, we're not bothering with it because I'm like, I don't have time. I don't want to deal with it. For some other families, that could be helpful.
You said, I just want to ask a quick question. On the age 26, if children are disabled, normally that age doesn't kick in. Is that correct?
That is not correct. Do not make that assumption. Okay. Do not make that assumption. Most health insurance companies kick your child off at age 26, regardless if they're disabled. Not all, but many. It depends on your employer. If you're with a bigger employer, a lot of times you have to appeal for that. It's not an automatic. My daughter's dad works for the University of Missouri. So if there are some caveats around, like she has to be residing with him under the same roof for her to stay on his insurance. She meets the disability part of it and the dependent part, but she has to be residing under the same roof as him. Well, that probably won't be the case. She lives with me most of the time, or will be in a group home of some sort. So it's not automatic. If you are a federal employee, it is automatic, but you still have to apply for it. Usually about, I believe it's 90 days prior to, but most companies do not make that assumption. I had a few clients that thought the same thing, that, well, my kid's completely dependent and is disabled. Don't they get to stay on? No, that is not the case. So that's why, again, getting Medicaid at 18 is much easier, or especially if your child's under 18, get them in that system now. because it is much easier to prove a disability prior to the age 18 than after. Now with FOP, because you're born with it, I think it's relatively easy, but I would, again, the sooner you can get into the system, do it, because it's a processing nightmare a little bit, but it can be very helpful.
Thank you.
Yep, you bet. Okay, next slide. This is, so SSDI. SSDI is much easier, in my opinion, than SSI. So SSDI, it doesn't matter how many assets an individual has. It's based on if they meet the definition for Social Security Administration, what they say is disabled. Let me pull this up. Hold on, I got off my notes here. Okay, so in this scenario, let's say your child starts working and has been since, I don't know, 16, 18 or whatever, but it's becoming, they're not making very much because they're only working part-time or whatever. They could potentially, after they've worked enough quarters, it used to be you had to work 40 quarters before you qualified for SSDI. Then the government realized, well, that's not fair for somebody who becomes disabled in their mid-20s, or they haven't worked 40 quarters yet. So there's a sliding scale from when you start at age 18, basically, of how many quarters you have to have worked consecutively to qualify for SSDI. Once you hit that 40 quarters, then there's some other rules about continuous work employment and stuff. And obviously you had to have contributed to Social Security tax. So like any situation where it's like you work for a state employer that you're exempt, you're not going to qualify for this, but your child potentially could qualify for SSDI. As an adult, the definition for Social Security is that the disability that they have is medically proven to be physical, which FOP qualifies for. I think I'm almost certain FOP falls under Social Security Administration's compassion care definition, which is it's an automatic. You have FOP, it's an automatic, you're considered disabled. But the other piece to once you're 18 is it's not just falling under that definition. It's can you hold gainful employment? And gainful employment is defined as being able to work and make more than $1,310 per month. If they make less than that and they have the FOP, then they are technically qualified to get SSDI. And they've worked enough and contributed. But it won't be much based on your kids' working history if they haven't worked very much or their income's low, but it would be a little bump up. The reason that I would go through the headache of this, even if it ends up only being $50 more a month, is because on the 25th month, regardless, 25th month of getting SSDI, it's an automatic, they get Medicare. And Medicare gives you a lot more options for provider care than Medicaid. So if your child only insurance is Medicaid at that point, then they get Medicare first, they do not lose their Medicaid, and you have a stacked. So you have a broader coverage and also more choice. So that is why the SSDI part becomes important if your child is working, to try and see if they can qualify for SSDI on their own working history. Now, if they're working full time and making $40,000, $60,000, $80,000, they're not going to qualify for SSDI because they're making too much. But just so that you're aware of that.
What is it being as a student change the sliding scale?
It does not. If they're not
in school.
No, that's not going to change it. They would. Let me get to the next slide, because your child could potentially qualify for SSDI based on mom or dad's working history as well, and they never have had to work or pay into Social Security a day in their life. So let me get to the next slide, and I think that might be a little bit more helpful. Okay, so how does a kid get SSDI if they haven't worked, or they haven't worked enough, or they're still a minor child? If mom or dad is drawing SSDI themselves, so they're disabled, or mom or dad is drawing Social Security retirement income, disabled a child, if they meet Social Security Administration's definition for disability, and again, once they turn 18, the added part is, can they hold gainful employment? So making less than $1,310 per month. That individual qualifies for SSDI based on mom and dad's working history, if mom and dad paid into Social Security. So the reason I keep saying that is because if somebody worked for the railroad, their child doesn't get the benefit. And there's some other exemptions where, like, if you don't pay Social Security tax, your child's not going to get this SSDI benefit based on your working history because you haven't paid in. But that benefit can be equal to 50% of mom or dad's Social Security monthly benefit. So instead of getting the $794 per month in SSI, potentially they could instead be getting $1,000, $1,200, $1,500. Again, not tremendously huge, but that's considerably more, especially if your child is working but only able to make $500, $1,000. You know, that's a big deal there. So that's number one, and it doesn't affect mom or dad's benefit. There is a household, even if your child's not living there, there's a household maximum. So usually it's about 150 to 180% of whoever's parent's monthly benefit that's based off of. It is not stacked. So if mom and dad are both drawing Social Security retirement income, it's not that child gets 50% of mom's and 50% of dad's. It's whoever's higher. They get 50% of whoever is higher. It's not stacked. But still, that's a benefit that stays with your child for life as long as they meet the criteria of being considered disabled. And then once a parent passes away, that bumps up to about 75%. Again, there's some caveats that could happen if there's additional children that are adults or minor children that are still on or whatever. But generally speaking, it's about 50% until a parent passes away, and then it becomes 75%. And again, the other piece to that is the Medicare piece. So when you are sitting down with your financial advisor, this is another reason it is so important to sit with somebody who has that CHS&C and knows special needs planning, because they're going to know this already. The recommendation of a typical financial advisor, oftentimes on Social Security, when to draw, because it's taxed, and if you don't need it, they'll tell you wait until you're 70 until you have to draw, because then your benefit and your ROI tends to be higher. But that's a totally different conversation when you're talking about an adult child with disabilities, because the benefit to your child, even if you're taking a smaller amount per month and being taxed on it, plus the Medicare piece, pays for itself. So it's a very different look when you're talking about your own retirement income planning. And that's why, again, I cannot emphasize enough, make sure you are working with a special needs planner, even for your own financial planning, because that has to be part of that conversation. Okay. Question?
I just have a comment on Social Security disability. When I drew it, when I think I was 21 at the time, I had been working, and you know, you fill out that long sheet of, or you know, the form for disability. They didn't believe that I was as disabled as I was, and they denied me.
Yeah,
so there's a denial process that you have to take into consideration.
Yeah.
For
well, an SSDI, no matter what, Social Security, no matter what, is usually a 5-month wait period. Mm-hmm. So they'll back pay you if you win that. It can be, I will tell you this, that is an art form of itself and a science, and it can be a headache. Once you finally get it, it's good, but trying to get there. So a lot of times you do have to employ somebody, but again, employing an expert, what you will end up getting ends up paying for that expert versus not having it. So, but there, sometimes you do have to involve, and you're right, it's an appeals process and it's not easy. And every time you call Social Security, you get a different person. So sometimes employing an expert is helpful.
That's why I'm saying everybody who's listening who has an FOP child, when they get to the disability part, don't feel depressed when they deny you.
Well, in FOP, I need to go back and check the compassionate care, but Social Security Administration has some diagnoses, a long list. I'm almost certain FOP's on there. If not, it's an automatic. Oftentimes you're having to tell them though, this is on the compassionate care list of diagnoses. I'm almost certain that you guys are.
3 years, because I don't have to do anything more now.
Yeah, now that they understand.
Yep.
Okay, so special needs trusts. Next, now we're going to get to the legal aspect. If I'm hard on time, you guys just let me know, because we've gone in so in depth on these things, which is awesome, but I just want to make sure we get through this stuff. So if I'm going long on time, just cut me off if need to be, because I could go on forever.
Maybe we've got probably about 20 minutes left.
Okay, we should be good depending on the number of questions we get. So special needs trust, guys, this is how we protect. So ABLE accounts, I mentioned there's, you can only put $15,000 in a year. if you're on SSI, you got to keep that balance lower under that 100,000. The maximum that can be held in a lot of these accounts is, you know, maybe 300, 500,000. If you're leaving, let's say, your entire estate to your child, it's likely worth more than that, what you can put into an ABLE account. So you would do it inside of a special needs trust. You have to work with a good estate planning attorney. And again, here's where you need another subspecialist. It's not just an estate planning attorney, it's somebody who knows and does special needs trusts a lot. The laws around special needs trusts are very specific. They vary by state. It can be very complex, and the laws are constantly changing. So you need to make sure not that you're just working with an estate planning attorney, but somebody who does special needs trusts a lot. Questions that I have asked as kind of litmus tests is how many of these special needs trusts have you had to defend in Medicaid court? If they are in this space, they have been at Medicaid court defending one of these things. It's inevitable. If they've never, and they say, I've never had to do that, you need to find a different estate planning attorney to help you with your special needs trust. So I just want to make sure of that. The other thing is I've had families come to me and say, oh, well, my brother-in-law is an attorney at this big law firm. I mean, he's a divorce attorney, but he said he went into the database and pulled the document and filled in the spots. Guys, please don't do that. That is not how you want your special needs trust. Don't go to LegalZoom. And also, if you get free legal services or as an employee benefit, that is not where you need to do a special needs trust. They are unlikely to have the expertise you need. You're going to have to pay for somebody to do this for you. Our platform does have an intake process and creates a special needs trust for you, but it's just a draft. We do not practice law. The founder of our company is actually a 30-year estate planning attorney who does special needs trusts, but he's in New Jersey, Pennsylvania, and Connecticut. And so we did have the special leaders at the Special Needs Alliance look at our 4 drafts that come out and reviewed all of those and everything. They are really good special needs trusts, but they're drafts. Every state has to have different language and has different laws and nuances and everything. So you would have to take it still to legal counsel for review. It's much cheaper, but you still have to take it to somebody to be reviewed and executed. So anyway, just make sure that you know that you are working with somebody that knows what they're doing, because if the special needs trust is not set up correctly, it can be a nightmare when your child inherits their inheritance and you're no longer here, but then they lose their benefits. It can be a mess. So just making sure that you understand those things. Also, somebody was asking me like, well, really kind of what's the point of the ABLE account anyway? ABLE account can pay for basic things like rent, mortgage, utilities, groceries, those kinds of things. Special needs trusts can't. You'll sometimes hear these called supplemental needs trusts. They're there to pay for the things that government benefits do not cover. So it cannot pay for mortgage, rent, basic utilities, groceries, those kinds of things. It can pay for clothing, it can pay for furnishing a home, it can pay for those things, but it's not that black and white either. So when we pick a trustee, you have got to make sure it's somebody that really understands POMS, which are the manual or the instructions and guidelines that Social Security Administration says what a special needs trust can and cannot be used for. And you also have to somebody who's financially savvy. It is a science on this. And that's where I find that we'll talk a little bit about these trust roles, but I really want to talk about trustee. Many families say, okay, well, I'm just going to make my other adult child a trustee or my good family friend. But generally speaking, most people have no idea what that role means. That is a legally binding fiduciary role. And fiduciary means that if they mess up on purpose or not on purpose, they can be sued. Now you may say, well, we would never sue, or my loved one with disabilities would never sue. It's not up to them. It could be a social worker. It could be a financial advisor. It could be anyone can sue them, including Medicaid, for misappropriation of funds. So I think families don't always understand the role of the trustee, fully understand and grasp that responsibility, but be wise in what you choose. And so that's where a corporate trustee may make sense, because a corporate trustee carries errors and omissions insurance. If they mess up and get sued, that trust is being, refilled, and nobody is having that whole saga, that's a family member. And so either a co-trustee, or we'll talk about trust protector here shortly. The beneficiary is the person who benefits from the trust. The grantor is the person creating the trust. Oftentimes it's the grantor's assets that are going to go fund that special needs trust, but not necessarily. The trustee is the person I was telling you, they're the gatekeeper. They determine, is this in compliance with the trust? And is this, can we make a distribution? Does this comply with all the government regulations around special needs trusts? Because keep in mind, that child or that individual may not be on government benefits now, but remember I talked about the 5-year look back. But what if they need it in 5 years from now? So we got to make sure that we have that. Now, there are some different kinds of special needs trusts that we can, what's called a toggle. You can have a testamentary trust that toggles to, that has language that toggles to a special needs trust. So it's not quite as strict. And there's language, our trusts have this language to toggle it. It says if they don't need a special needs trust now, but maybe in the future, this automatically toggles, and that there's language in there that protects their government benefit eligibility. So again, that's where working with that estate planning attorney who really knows special needs trusts is going to make a huge difference in making sure those protections in place. I recommended to my clients when I was a financial advisor of choosing a corporate trustee, making sure it's one that specifically works a lot with special needs trust. Hope Trust is one that does only special needs trust, but there's other companies out there that do both trust and special needs trusts. There's just a whole different nuance and expertise when it comes to special needs trust versus any other kind of trust. But a trust protector then gives that family member the control that if a trustee is not doing the job or doing it well, they can hire and fire the trustee, but they don't have that fiduciary responsibility for misappropriation of funds. Or any kind of thing like that. And that might be a better role so that you feel, because many families said to me, but I don't feel comfortable having some bank officer at, you know, the bank or some trust officer at the bank being in control of whether we do a distribution from a special needs trust for my loved one. They don't know my loved one. I want my family member to have, you know, be able to have a say, so the bank's not holding on to our money and never spending it. So that's where that trust protector can be really helpful. And also making sure that you're working with the right type of corporate trustee as well. Taxes. Okay, guys, special needs trusts do not get special tax treatment, which means they get trust tax. They're taxed just like every other trust. Trust taxation can be ugly and high. Anything that is income producing inside of the trust is taxed as trust income. At the federal level, that's a very marginalized, compressed tax rate, meaning $13,000 of annual income is taxed at the highest marginal tax rate of 37%. So how we fund the special needs trust and the assets going in, you also want to make sure that you are working with an estate planning attorney, a financial advisor in this space, and a CPA, because nobody wants a big inheritance to Uncle Sam. You want more to go to your family. So having 3 work together is really helpful when you're trying to create a funding plan. Your special needs trust is a really expensive document that's worthless if you do not retitle and update the beneficiaries of your assets. Because if it's outside of the trust doesn't have any control over those assets. And that, so that is one piece that I continue. Your financial advisor should do an audit every single year of reviewing everything and making sure titling and the beneficiaries on your assets. But you may have assets outside of there, whether it's a home, whether it's you know, ownership in a business or anything like that. If you don't have a special needs trust or it's not titled correctly, it goes into, it hits your will. If you don't have a will, then it goes to what the state's plan is. The state has a plan for you if you don't have a plan. And that plan is, it goes to next of kin. If you're married, it goes to your spouse. If your spouse is dead or you don't have one, it goes to your children outright by name. If your children are minor children, it gets held with a conservator until they turn 18 or 19 or 21, depending on what state you're in. But at that age, or if they're older than that, it goes to them outright by name. Your loved one with FOP, if they're dependent on government benefits, will lose all of their government benefits immediately, become suspended if it's over $2,000. The government doesn't care. Your state does not care if they inherit something and then they lose their Medicaid benefits. So not having a plan is worse. Get a plan in place. So I just want to make sure you understand that. And then let's talk real quick, first party versus third party. So let's say that your child inherits something by name and you're like, oh, okay, that's now their money regardless. That would be a first party, setting up a first party trust situation for your child. They are the grantor and they are the beneficiary. They cannot be their own trustee, but it's their money going into there. Third party special needs trust is what you, mom and dad, or grandma and grandpa set up for your heir that has disabilities. The main difference between the two is Medicaid payback. First party special needs trust, when that beneficiary dies, what's left in that trust first goes to Medicaid to pay back any supports or services they've provided. Third party, that's not the case. It goes to whoever the successor beneficiaries are of that trust. So that is the reason why also doing your planning as a parent or a family member of someone with special needs is really important, because who wants it all going back to the government? You want it to go on to your heirs who may have been helping to support this individual or helping with caregiving or whatever else. So that's where that third party comes in. But like I said, if, you know, great Aunt Bertha leaves something and nobody ever knew that she had a sweet spot for your child with FOP and left everything to them, there is a way to fix it. It's just a mess. Because like I said, those benefits immediately are suspended, and then you got to create a first party special needs trust. It can be fixed, but it's a mess. So I've had a couple situations that have come across my desk, none of which were my clients, but were referred to me after the fact. So that was one of them. Was it was I can't remember if it was a great aunt or a great uncle, but had nobody realized that they had left the estate to the individual with disabilities by name through will. So you need to make sure whenever you have family gatherings that, you know, hey, I'm not making any assumptions anybody's leaving anything to my child, but if they are, you need to name the special needs trust if you have one that stands alone, or it shouldn't go to them by name.
So Debbie, the only reason why you really want to set up the trust is to keep eligibility for the other Medicare, Social Security things, yes, right?
Medicaid
okay.
And all that.
So there's no real advantage of doing it unless they are collecting Social Security or Medicare or Medicaid.
I don't have a crystal ball to tell me if they're going to be needing that in the future, though. If you have somebody with FOP who right now may be high functioning, but then ends up in 10 years from now unable to work or working on a limited I sure as shoot don't want to be leaving stuff to them that in 10 years from now is going to be counted as assets. Right. And so you can leave it to them in a trust, and that way. The other piece about a trust, and this is any trust, not just specific to special needs trust, but let's say that individual's married and gets a divorce, nobody's touching, that is not included in their, that's not split, that stays with that individual. So that's another thing. There's a protection mechanism there from like, or if they go bankrupt or anything inside the trust is not touched.
Right.
So a couple other scenarios that I've had, I did have somebody call me who nothing had been done. Dad dropped dead of a heart attack at age 50. Child was 25 years old. Now this was a developmental disability situation, but the child had no health insurance. They lost their Medicaid because they had a family farm. And so he had had diabetes that wasn't managed well, ended up in the hospital for 3 weeks, and it cost $80,000 in cash. First of all, when we're doing funding sources, but if you do know planning, a farm or real estate is not exactly liquid. So that's problem number one. And then number two, it doesn't matter if it's liquid or not. He is still liable to pay that bill back in cash. And so again, because he lost his Medicaid because of that. So those are the scenarios that I just want to make sure families are thinking about, is this is why this planning is so important. It's not just the legal aspect, but that funding plan and everything else, but getting your ducks in a row is really important. Okay, moving on. So do we need an ABLE account or do we need a special needs trust? The answer is they're not apples to apples. ABLE accounts are great and do serve a certain role. Special needs trusts serve a completely different role, and some of the things they can do is overlaps. So, you know, we talked about an ABLE plan. Anybody with FOP is going to be able to have either one, but a special needs trust has no age limits, whereas an ABLE account you have to have a disability present before 26. Real easy to set up. It doesn't cost much. Most ABLE accounts to open one up, it's not costing. You have to deposit 25 to 50 bucks. I think I've seen 1 or 2 states where it's 100 minimum to open the account. And you don't have to do an attorney. It's all online. It takes 10 minutes. It's super easy. Special needs trust is going to require an attorney, period. And it's going to come with a cost, a fee. Contribution limits to an ABLE account is $15,000 per year, and that's in total, not per contributor, in total of everybody making a contribution. If the individual, I do want to say this for your group, if the individual is working and they're not contributing to their employer's retirement plan, or they don't qualify to contribute to that, then there's a caveat that they can have 15,000 contributed, but then they can also contribute on top of that the lesser of their wages or the federal poverty level, which is, I think it's between $12,000 and $13,000, but it's the lesser of the two. They can contribute that on top of the 15,000 because the federal government wants to encourage people to save for retirement. And then third-party special needs trust, there's no limit on what you can contribute. You can contribute as much as you want. It doesn't have to necessarily be cash. It can be real estate, but ABLE accounts, you can only contribute cash. And then,
so Debbie, if just a quick question there. So if they're working, but they're not getting through the personal deduction because they're not earning enough, then the ABLE is going to give them all the benefits of a Roth.
yes,
They aren't paying any tax anyway, but have the added benefits that come with the disability attributes of the ABLE. So probably better than a Roth to do an ABLE until they get to an income level where they're paying tax.
correct. Exactly. An ABLE account actually acts like a Roth, if you will, except you can tap into it now. They don't have to wait until retirement. There is no penalty to start using it today. So let's say, okay, we're saving into this, but something comes up and they do need to tap into it. You're not going to be dealing with some of the limitations that you have with Roth. Granted, a Roth can be used for a lot more things now without a tax penalty, depending on what it's like, medical stuff and everything, but the ABLE account you can use now. So, but yes, basically what you said, yes.
Yeah, and I was trying, you don't even get a deduction for a Roth, so you don't even have to wait.
Right,
I mean,
right.
It's probably just better. Yeah, okay, thanks.
And then ABLE accounts you can sometimes use, again, it depends on the state's program you're using, but some of them you can use, they have a checking account function, they have debit card functions, they can do preloaded debit card. I mean, there's all different kinds of things. So there's a lot of options there. Again, special needs trust, there's a trustee that has to approve every single distribution. So what I want to talk about though, for somebody with FOP, again, they don't want to necessarily have to ask every time they need a distribution. You can have the special needs trust fund the ABLE account. And so I've had clients who have had their estate planning attorney actually put language in the special needs trust that says if the ABLE account has not had its maximum annual contribution, have the special needs trust fund that, because then the individual with disabilities can use the ABLE account however they want. They don't need to go through a trustee. So that's how you use the two together. Plus, if somebody's living somewhere, and let's be honest, if $794 a month is supposed to cover rent, food, basic utilities, well, there's not a whole lot of places in the United States that's actually going to cover that. If somebody supplements that, then you have a problem because their SSI goes away or is reduced. But if the ABLE account supplements that, you have no issues. And the special needs trust can fund the ABLE account. The special needs trust just can't pay for the same things directly from the trust that the ABLE account can. And that's how you use the two tools together. And that's why I tell most families, it depends, but you probably want both. Okay, so other important legal things, and this is going to be for anyone, but especially for our loved ones with FOP. And this is not a topic that a lot of people like to talk about, but we need to address. Powers of attorney. We really need to talk about this. So powers of attorney allow a person to act for another person, and these are usually used while the person is actually still alive. But generally, when that person's ill, disabled, incapacitated, or they can't physically be present. So a durable power of attorney generally remains in force to manage the individual's affairs, oftentimes during incapacity. There's special or limited POAs. It's often when you can't be present. So let's say, you know, I need a check written and I'm going to be in Cancun. So I have this one transaction this individual can do on my behalf, and that's it. There's also springing power of attorney, and this means their rights or their control springs into effect upon incapacity. So let's say during surgery, but immediately ends once they have capacity again. So once general anesthesia is off and they're able to function, then that springing power of attorney, that's cut off. They're what they can do. Now, powers of attorney can provide legally very broad or limited authority to make decisions about property, finances, or medical care. So if there's a need to pay a bill or transfer monies or anything like that, that can be done. But if you are actually incapacitated, let's say you're in a coma, then general powers of attorney usually end with true incapacity. So like if you're in a vegetative state, that's where your durable power of attorney kicks in. So understand that the durable power of attorney can act on your behalf in most matters during your incapacity. However, they can't make health-related decisions. So that's where the healthcare power of attorney comes in. You'll hear you'll hear also healthcare proxy, but healthcare proxy is the document that gives the healthcare power of attorney the rights to make those decisions on your behalf. There's also what's called a durable power of attorney. That's for finances to handle the money stuff during your incapacity. And then the springing POA defines what kind of events or level of incapacity their powers spring into effect. So generally, these all need to be legally documented. You can't have a conversation or write it on a piece of paper and pen and say, this is it. You need to really work with an estate planning attorney because each state's laws around all of these things and how they are filed, or if they need to be filed, or if they need to be notarized, or what that needs to look like and what language needs to be involved is state specific. So please, you're going to have to probably meet with one about a special needs trust. I would address these issues as well. Generally, powers of attorney, regardless of powers and state, do not allow for a power of attorney to do certain things, and that's change any kind of estate plan or will, vote, or get involved with marriage, which obviously, why would we want somebody else to marry or divorce for us while we're incapacitated? So these next ones are kind of the things we don't like to talk about too much, but what to do when we're unable to express our wishes ourselves or nearing death of our health is starting to take a turn for the south, and it's looking like it's going to end in death or be terminal. I'll tell you, this is one of the best gifts that for those that have FOP or any of us, it's one of the best gifts we can give to our family because it says what you want for yourself. It'll avoid major battles. And I'll tell you as a financial advisor, we get involved we don't get involved. We get to hear about all of this because money and death does not bring out necessarily the best in families. And so it will avoid major battles within your family if you have this set up. You know, no one wants to have to try and figure out whether you want to live on in a vegetative state or to let you pass away. Nobody wants to do that, and everybody second guesses themselves. And then there's always a family member who disagrees with the decision made, and then there's a rift in the family forever. So I definitely get this in writing. The other piece is, you know, do you want CPR? Do you want extensive things done, heroic measures, placing feeding tubes, putting breathing tubes in? What kind of measures do you want, or do you not want them? Again, an advance directive is a set of instructions someone spells out in advance that says, this is what we want for our healthcare wishes, whether I'm incapacitated or I'm becoming terminal. A living will is a type of advance directive that becomes effective once you become terminally ill or considered end stage of a disease, or if you're incapacitated. So, and then it also states if any life supports you want to be done. Again, that was the ventilation, the dialysis, tube feeding, blood transfusions, all that. It literally lists out what you do and don't want. And then a DNR states what to do if your heart stops beating, meaning, are they going to trach you? Are they going to put you on a vent? Are they going to shock you? Are they going to do all these things or not? And that is what that does. So finally, for some, and usually you see this with long-term incapacity, when we talk about conservatorship and guardianship, this is truly when we're dealing more like with a cognitive impairment, dementia, those kinds of things. But a conservator is assigned to manage the individual's stuff. So property, finances, money, assets, those kinds of things. A guardian is of the person, meaning where they live, medical decisions, those kinds of things. So that's the difference between the two. I don't think you guys have to deal with that quite as much with FOP as you do with some other disabilities. But I cannot state this enough. Get it in writing. Get it in writing, make sure it complies with your state's law. Again, that probably requires involving an estate planning attorney, because depending on your state, it may need to be notarized or something else, as well as filed with the court. But this way you can make sure what you want, or your child, once they become of the age of majority, they can say what they want and get that in writing. All right. So we've addressed the money aspect, we've addressed the legal aspect, we've addressed the government benefits aspect. And again, but how do we get the kind of all the other information we need to know? How do we get that all organized in one place? This is where a life care plan comes into place. So a life care plan is a lot more robust than a letter of intent. Anybody who's done estate planning or met with an estate planning attorney, a lot of times in your estate plan, they have you do a letter of intent for your loved one with disabilities. It's usually a couple-page document. I've seen a couple that have been a little more robust and maybe 10 or 15 pages. The problem with the letter of intent is it's a piece of paper that goes with your estate plan that usually goes in a binder that's sitting up on a shelf, and it gets looked at every 10 or 15 years. Meanwhile, your loved one with disabilities, things are constantly evolving, changing, whatever, as time goes on. So in order to do that, that's where a life care plan comes. And it needs to be on a platform that is, one, accessible but secure, accessible to your successors, or that it can be made accessible to your successors, and that it's readily available, usually by mobile, so that, and online, so that those updates can be made. I have a platform, Hope Trust offers a platform like that. I have it for my daughter. So when she goes to a doctor's appointment, I'm pulling up on my phone current medications. We're going through those. If any changes are being made, I'm making that change right now. I used to try to do it through Google Docs, and like I had lists, paper lists here and a file over here, and it was a disaster. And I realized that my kid's dad didn't know all of this stuff because I do most of the care and managing it. And I mean, he wasn't going to know where to start if I got hit by the proverbial bus. So again, making sure all that information, it gets you organized now, you, the person with FOP, or the parent, or whoever's helping to care give, gets everything organized. But then if God forbid you get hit by the proverbial bus, it's all organized, and whoever's stepping into your shoes or whatever, it's all there. You, at least that piece of it is continuous. So I definitely recommend that part of it. Let's see. Again, we have a platform. I do have to plug Hope Trust a little bit, but we do have a platform. It's easy to update online and mobile. It's secure and accessible, and each user you can grant different levels of access so they only see what they need to. So for my daughter, like, she is a case manager through her Medicaid waiver. She constantly needs to know who her current providers are and who her current meds are, or what her current meds are. So she has access to that, but she has no access to the finances, and she doesn't have access to her documents. We have her Social Security card on there, her birth certificate, those kinds of things. My daughter, we will be getting guardianship next year. Her guardianship paperwork will be there. And that way we don't have to carry around a paper file. We have it on our phone. Our phone is always with us, but not all the other stuff. So that way it's with us no matter what happens. All right. As a parent of a child with special needs myself, I completely remember the day my daughter got her diagnosis. The air went out of the room, and I think it was 5 or 10 years of just trying to get through the next 5 minutes of figuring everything out and everything. I get it, but you have got to plan for yourself as a parent. And the reason for this is because if at the end of your life, there is nothing left for your child to inherit, you really don't need to worry about special needs planning. So I realize as parents, we often make complete sacrifices, don't worry about ourselves. I've heard parents sit down with me and truly believe they are going to work till the day they die. And I will tell you, I've also seen those parents when they're 65 or 70 turn to me and in tears and say, I can't do this anymore, or I'm facing a medical crisis. What am I going to do? At that point, it's a little bit late to start doing that planning, but you can do that planning now. So again, working with that financial advisor, you know, think about the person, if you're down to one person working in your household and the other person's managing all the care, what happens if that person can't work anymore? and that income's not coming in. Now who's paying the bills? You know, so we don't want to have those added stressors. So again, working with a financial advisor to make sure you get the risks off the table, or that you're protected and it can at least sustain. But also thinking about your own retirement. Things happen. We know that. We wouldn't have kids with disabilities if life didn't throw us curveballs, but making sure you have protections in place and that you're still continuing to plan. I realize that it may not look the same plan that you originally had, but we can get you in a place that you're in a good place, that you can leave inheritance for your child and your child is supported. So I just, that's my soapbox, but I just want to make sure that families are planning for themselves. So finally, just a few more kind of planning considerations. As I mentioned, you need to plan for yourself. Second piece is make sure you have a funding plan for that special needs trust and make sure it's efficient. Again, nobody wants to save all this money and then have half of it end up with Uncle Sam. So that's why working with the right professionals is really important. Your special needs trust will only work if you have titled your assets and updated your beneficiaries appropriately. Your estate planning attorney will help you with that. So making sure all of that is updated. Again, you got to think back to, do I still have a 401k from when I was 25 years old that's sitting out there that I forgot to roll over? If that's the case, get it rolled over, or make sure at least it's titled. Again, if you've addressed your estate planning, your will should catch any of those free falling things that just you missed, and will say like anything that would go to your child with disabilities needs to go to their special needs trust, but anything that's caught by your will still goes to probate. And depending on the state, that could be a 9-month to a 24-month process. If you die tomorrow, we probably still need cash the next day for your loved one. So making sure that we have these things addressed is really important. And then, do you have the right team in place? Not just the professionals. I've talked about the subspecialty kind of specialists and professionals you need, but also your family and friends. So here is something that, another thing that I have found is that families assume because they're family that their family members want to step into the role. That's not necessarily the case. So I suggest you have those conversations. If you're looking for somebody to be a guardian of your minor child, or you're looking for somebody to help out with the support of your loved one, you need to have that conversation, including if it's your other adult children. They may say no. I would rather somebody tell me no now so I can make some plans and arrangements than after I'm dead, there's nothing I can do about it. So be okay with what somebody says, and okay that they're honest and say, I just can't take this on, or I can take this little piece on, but I can't do all of this. So I recommend that, but you need to make sure that you ask them, but you also need to make sure they understand the responsibility they're taking on. Just because they reside in the same house as you and the person with the disabilities doesn't mean they fully understand the responsibility they're accepting. I've had many adult siblings say, I knew it was a lot. I had no idea. And I'm overwhelmed because I've got a career and I'm taking care of my own kids. And now I'm taking care of my adult sibling. And oh my gosh, I can't believe my parents did all this. So making sure that it's okay to split it up. We as moms and dads take on tremendous amount, but it's going to take a village to step into our shoes and make sure everything's taken care of. So again, thinking that way is really helpful for a lot of families. So just to recap, it takes a village. It's a process. It's a process that is never ending. You're going to continue to review. Please don't get through this. It's a journey. I understand it. It's complex, but it's never ending. You'll get the big stuff done, and the review process is usually much easier. But once you get there, it's not a destination. You're going to continue to review it each year, at least, with your financial advisor, with your estate planning attorney, and just making sure that laws haven't changed, whatever's going on in the family, that your loved one hasn't changed or their needs haven't changed, that things don't need to be updated and tweaked. And then finally, remember to take care of yourself. Like I said, when you're on an airplane, they tell you, hey, put your oxygen mask on first before helping someone else. You're a lot more productive that way and helpful. This is no different. And that is it. I think I'm right up against my time limit, so I apologize. But I don't know if we have time for more questions.